So we've got queued up here someone that is about the best fog cutter one could find. Truly, Michael Carroll is not only the director of the Program on Information Justice and Intellectual Property at American University. He's a co-founder of Creative Commons, and he is one of the pioneers, and in my view, really one of the luminaries in this sort of area of kind of keeping the fog at bay and finding a way through the fog into the sunshine. I was delighted when I heard that Michael was going to be able to join us, and you're in for a real treat. So Michael, welcome.
Thank you very much for that kind introduction. Now I should say, because I'm a lawyer, I'm just going to be cautious. So I am on the board of directors of Creative Commons, and Heather and I also serve on the board of directors of the Public Library of Science, both of which will get mentioned in this talk. I'm not representing either organization. I'm here on my own to talk to you about copyright and authors' rights and open access. And, you know, what I want to talk about is what's going on at the macro level first before we get into this. I think what we're doing is we are still adapting to the change in the environment that, that the internet has brought to us. We think we get the internet, but we don't yet. In terms of the way we publish educational resources, research, we are still adapting to the digital environment. We still talk about scholars publishing papers, right? We haven't really adapted. And here's where I think we are with open access. And I want to say a word about open educational resources too, because that was, Mark's talk was really exciting, and I'm working on that kind of stuff too. So I look around the audience and I see people of different age demographics, but some of us at least can go back to, say, let's go back 25, maybe even 30 years. And let's think about a different kind of environmentalism, sort of recycling behavior. So if you wanted to recycle your newspapers or your cans or your bottles 25, 30 years ago, you just haul it out to the curb, right? No. How did that happen? Well, there was a small group of dedicated people who had in their minds a vision of responsible citizenship or responsible stewardship for the natural resources and the planet, who would get their rear ends up on Saturday morning and tie their newspapers up in bundles, throw them in the back of the car, burn some fossil fuels in order to go recycle their paper, their bottle. Because you had to do it on your own, you didn't have any support, but you had a vision, you had values, and you were going to express them, and that's what you did. Now, if you think about it today, all of us have the opportunity to recycle. You just go into the washroom and you got an opportunity to recycle. It's easy. It's become institutionalized. So those values that were held by a small group who were acting on that on Saturday mornings has become the norm. And how did that happen? Through a series of incremental steps. And we are in the same kind of process with regard to open access to the scholarly literature. And we're at an earlier stage in terms of open educational resources. But in both cases, the movements were started by small groups of people who had a vision about what the internet could do for society, what the internet could do for the project of higher education. And we are now in the process where we're moving from the sort of a la carte, one by one way of doing things into the institutional phase. In the early days of the open access movement, the way papers became open access was when individual authors got the publisher's form that said, here, I'll do you the favor of publishing your work if you give me all your rights. And somebody would scratch out the thing that says, I'll give you all my rights, and say, well, I want to put it up on the internet. And then they'd send it back. And in the early days, the publishers didn't really pay attention to those because there was such a small dribble, that they just said, fine, whatever. And we started getting papers up on the internet. We also had people who just didn't care what the paper said and threw their stuff up on the website anyway. But that was driving to the recycling center on Saturday morning. That was the phase of open access. We are now moving into a phase where authors are getting more institutional nudges, pushes, requirements, to actually engage in this behavior, and they're getting more institutional support in the forms of institutional repositories from libraries and other kinds of sort of support for the open access behaviors. And just a word on the open educational resources. That's a really exciting project as well. And just to respond to the question about, you don't have to be innovative to use OER anymore. So the OpenStax College, they've got a textbook. It looks like a textbook. The difference is that the author of that textbook was paid once to produce that textbook, and they agreed that they'd use their copyright and put that textbook out under a Creative Commons attribution license, which means anyone else can take that book and reprint it, mash it up, do whatever they want, because it's pay once, use forever is what OER. And just because we're talking about OpenStax, when I had my Creative Commons hat on, I got invited to the State Department because in the final days of her being the Secretary of State, Secretary of Clinton adopted an open book project where we're going to take, the United States is going to take those OpenStax STEM books and bring them to the Middle East so that they can be translated into Arabic, so that they can actually be used to provide sort of open STEM education in that part of the world. So we've got the United States government buying in to open educational resources. We've got the United States government buying into open access with Friday's announcement. So we are moving from not just sort of small institutions, but it's becoming governmental policy. So it's an exciting time. All right. Well, why we've Heather, some of my talk overlaps what Heather said, so I apologize to the extent that you've got to hear it twice. But copyright is at the center of the problems that need solving, that both open access and open educational resources are responding to. And the reason is because copyright gives you legal rights to control the redistribution of information resources. And copyright is given to authors, and authors are in an institutional setting in which they do not place much value on that copyright. What they really value is trademark. Trademarks are brands. Why do authors value brands? Because they want that brand on their CV to say, I got published in X journal. And so they swap their copyright for the publisher's trademark so they can stick that brand on their CV. And the problem is that the terms of trade don't represent the full set of values that need to be taken account of when that trade happens. Now, as a copyright lawyer, I have to say one thing that's interesting about the environment we're in is that authors get copyrights, but there's a rule in copyright law that says if the if an employee creates a copyrighted work within the scope of employment, our law treats the employer as the author, meaning the copyright goes directly to the employer. Well, faculty members are employees of universities, and scholarship is part of the scope of their duties. So there's an argument out there that actually the faculty don't own any of these copyrights, and we've had it all wrong since 1976 when Congress changed the law. I'm not going to take us down this rabbit hole, but I just want to say the foundation of this whole system is sitting on a fault line in the law where we might one day get litigation, we might one day get a court opinion that declares that actually all this time the university was the copyright owner, and those agreements that authors were signing were not necessarily authorized by the copyright owner. So now what do? We got a big mess. And different universities all have copyright policies that try to deal with this. And again, there's a rabbit hole there because there's so many technicalities in the law on that one that those policies don't always do what they say they do. But Rice University takes the position that it does own the copyrights to its faculty scholarship, and then its policy says, we hereby give it back to you, you guys can publish wherever you want. Other universities say, we think the faculty own their copyrights. So it's a fault line, but nobody's got an incentive to rock the boat and go to court and really get a final resolution, and so that's why we are all sort of rolling along. But I just want to put you on notice that's the state of affairs. Now the researchers, let's play along with the sort of general understanding that faculty own the copyrights to their scholarship and that they have the right to sign them away. Why do they sign away those copyrights? Well, publish or perish, right? And they're either not willing or able to be those Saturday morning authors who are scratching out the I give away all my copyright, and instead they say, look, I'm a busy person, there's the form, give me the form, I'm just going to sign it, and they move on. But what's changing is that other parties in the system are stepping forward and starting to discuss with the authors, either sort of jawboning them or through contracts saying, we got to change the deal. So funders are starting to say, actually, if you want our money to do the research, you can't just sign away the copyright that emerges out of that research. So what the Friday announcement is that the other $30 billion of United States funding for research is going to require that authors hold on to enough copyright rights that they can give the government agency or whoever is designated to provide public access on the internet a copyright license to do that. Because when you're on the internet distributing lots of copyrighted works, you can do that under fair use for a few things, but when it's a systematic distribution of all these articles, you need a copyright license to be able to do that. And you can only get a license from the copyright owner. And what's happened is faculty sign away the ownership rights to the publisher. And what we're saying now is, what these funders are saying is, you can't do that anymore. You've made a prior contractual agreement with us, the funder, not to do that. So now you've got a problem. You can't just sign the publisher's form, you're going to have to change it. That's been the state of play for all NIH-funded researchers and for researchers funded by a couple of other organizations. It's now going to be true for National Science Foundation, EPA, Department of Energy, Department of Agriculture. So librarians, get ready. You're going to have a new set of faculty coming to you and saying, wait, you mean I can't just sign the publisher's form anymore? Why not? And so there's going to be another cycle of education coming. But it's not just sort of funders saying, I want value for my money, I want return on investment. What's happened is, the reason it was okay, the reason it was ethical for a faculty member to simply not pay attention and sign that form in the analog era was there wasn't any other way to disseminate your work. But now the internet provides this opportunity to do it a different way. And when there's choice, then ethical considerations come into play, because now you have to justify your choices. And what we're seeing is a raised consciousness on a number of campuses where we say, okay, wait a minute, what are we here as a university to do? We're producing knowledge, we're disseminating knowledge, that's our job. We've got this internet thingy here that might help us do that better, but we've got a set of copyright practices that undermine our ability to use the internet to do the university's core mission. How are we going to react to that? So on a number of campuses, faculty have come together collectively and have basically collectively tied themselves to the mast and said, we will change our copyright practices. One by one is too hard, but if we all agree, right here, right now, we give the university a license, you can put my work up on the internet, and I'll just have to deal with the publishers. And what's happened is the libraries have then been empowered to negotiate directly with the publishers about how this university policy will be sort of implemented, so that the faculty member doesn't have to get in the middle of that. And so if the University of Oklahoma were to collectively adopt such a policy, it would then empower the dean of the libraries to have conversations with these publishers about how exactly they would use the license that they would get from faculty to make work open access. All right, so Heather had the more up-to-date version of this graph, but the number of these policies has been growing around the world, and this sort of trend line should look familiar by now. But that's a mix of, if you look at it, the pink is the funders, And the blue are the institutional mandates, which is a blend of university policies and other kinds of institutional commitments to making scholarship available on the internet. All right, so that's the overview. Right, so I'm a little bit, I get slide envy. All your attention is going out to the screens. So, 1, 2, 3, eyes on me. But this is really exciting, right? It's been a slow evolutionary change in the environment, just like the recycling practices have. But we really are hitting a moment where we're hitting our stride, where the wind is at our back. You hear more and more from publishers that open access is inevitable. I was in a meeting at the National Academies of Sciences yesterday morning, and a representative of the IEEE, the Engineering Society, said, we publish a bunch of engineering journals. Open access is inevitable. We had the folks from Elsevier, from Science Magazine, talking about what they're planning on, and they are planning on an open access future. So that's exciting. What we're really going to be wrestling with is how much is it going to cost, and what, if any, reuse right restrictions on the stuff you find on the internet do you have to deal with. So Heather's completely right that the debate's moving from access alone to access plus reuse, and what are the terms of reuse. So I'm going to get into that in a minute. But now's your little copyright primer. And I'm happy, if time allows, to do sort of any open access copyright questions. I know the campuses, all kinds of copyright issues bubble up. I don't restrict myself just to the OA questions if the dean will allow me to freelance. But let's get the basics about how copyright works. Copyright attaches itself automatically to what the law calls a work of authorship. A work of authorship is just any expression of the author through any that's fixed in any tangible medium. So it's when you have the ability to make creative choices, and those choices get expressed in words and pictures, et cetera, that's when a copyright attaches. So not too many people are taking notes. That's disappointing. But if somebody were taking notes, you would be making choices about which of my words belong in your notebook or on your laptop, and you would actually be getting a copyright in your notes as we speak. And federal law would be showering down upon you a set of exclusive rights to that copyrighted work of authorship. And because we have international agreements with our trading partners, the copyright you get from our law only stops at our borders. But don't worry, your notes are safe if they go to France or they go to Brazil or they go to China, because we have trade agreements that require those countries to give you a copyright too. So you're getting 200 copyrights as you type your notes. All right. But copyright, let's be clear about what it covers. It covers the author's expression. It does not cover all information that has value. So experimental data, and we're not going to limit this talk to the sciences at all, but I may use a couple science examples. Data is a good example. Factual information is not a work of authorship. It's a fact. There is no copyright in facts. You can copy factual information without worrying about copyright. When it comes to factual databases, the only authorship that you might have to worry about is the selection and arrangement of that data in terms of how you choose the field names and how you organize them. And if you want to copy all of that, there may be a thin layer of copyright that attaches to that piece of the database, but the underlying data is still in the public domain, free for copying, free for reuse. Right. Now, what counts as a work of authorship can be a broad range. It can be anything from a full-length book to a particular figure, a particular table, a particular graphic. As long as there's enough room for creative choice, the threshold of creativity is quite low. The Supreme Court has said a minimal spark of creativity is all it takes. So as long as you're making that minimal amount of choice, you're getting a copyright. The scope of that copyright will be bigger or smaller depending on the amount of choice. J.K. Rowling is going to get a big fat copyright on Harry Potter, whereas your choice of the 100 best restaurants in the Southwest is, you don't own the names of those restaurants. you just got your ranking, and that's your selection and arrangement, and you get a thin little copyright on your ranking. So when it comes to journal articles, who owns the copyright in the journal article? Well, we have to be a little careful. There may be more than one copyrighted work of authorship in the article. If all the component parts, like figures, tables, pictures, and things, were all created with the idea that they'd all be merged into one article, then there's only one copyright and it's jointly owned by all of the contributors. I would say, in my understanding of the way most scholarly articles work, that's the rare case. More often, tables, figures, and things are created separately and then put together, they're compiled, which means there are multiple copyrights. And that becomes a problem like in fields like art history, where you get the copyright in the author's text, but then you want to import all of these images that have separate copyrights on them, and you have to clear the rights to those copyrights in order to put the full article together. What does copyright give you? On that expression, you get 5 basic rights: the right to reproduce the work in copies, distribute, prepare derivative works, publicly perform, publicly display the work. Outside the United States, you get something called moral rights, which means even after you've signed away your economic rights, the author retains personal rights that cannot be given away. They have the right to be given credit. Our law does not require that the author get credit. That is not a requirement of US copyright law. It is a requirement of copyright law outside the United States. Oh, important. The scope is the work itself and anything that is substantially similar to the work. So when you're thinking about how far away from the original can I get and get outside of copyright's orbit, well, anything that's inside the substantially similar orbit is inside the scope of copyright and requires you to either decide it's a fair use or you get a license. And here this is in the scholarship, there's a misunderstanding sometimes that the temporal sequence of how an article gets created creates separate copyrights on each version. That is true, but it doesn't mean that you can hand the publisher the copyright to the final version that will be PDF'd, but I can take my earlier draft and license that separately, because once you give away the copyright to the final draft, anything that falls inside the substantially similar orbit is covered, and the earlier drafts probably are substantially similar to the final draft. If you've given away the copyright to the final draft, you also gave away effectively your ability to use the copyright in the earlier drafts. So in terms of having the rights to put it up online, you can't split the baby that way. It doesn't work. Now, there are small exceptions. I have to say, boy, I want to bang my head against the table when I hear these stories about people who go the other way and, they're writing a book, an author's writing a book, and they want to quote a Bob Dylan song. You got two lines from a Bob Dylan song at the opening of a chapter, and they write to Bob Dylan's music publisher and say, how much to clear the rights for this? And they'll send you a bill for $3,000, and I'm not making this up. You don't need to pay for 2 lines of Bob Dylan songs, okay? Copyright, that's not making a copy of the song, right? You're allowed to borrow small bits without copyright touching that, okay? Now, just because the publisher says they got a price for that doesn't mean you need to pay that price, okay? And so small borrowings are outside of copyright scope. In addition, certain temporary copies don't count. And this is mildly technical, but this is an example of sort of the hidden pieces of copyright. But this matters with respect to text mining, and text mining is where the action is now. So this is a hard part for the librarians in the audience. So you get these contracts and they say, you can have database access to authorized users, but no text mining, right? No mass downloading for purposes of analyzing the text. Well, let's be really careful about whether, when you sign that agreement, are you getting a license that you need from the copyright owner? Or are you, in fact, giving up a user's right? And you are giving up a user's right, and here's why. Because if text mining means this, so let's say the library has access to, an EBSCO or a collection of articles. And what I want to do is run a piece of software that makes a temporary copy of 10,000 articles. I only want to hold the whole article in memory for about a second while I run my analysis. And then I'm going to pull out all the words. So maybe it's digital humanities. I want to find out all the different times that a particular author uses this turn of phrase. Or I want to find out how many times these two things appear in the same. So the durable outputs of my analysis are just facts or not things that copy the expression. Then the only copyright hook that I should care about is that temporary copy that I had in memory for 1 second. And that is not a copy that counts under copyright law. And the reason is because the exclusive right to copy is technically to reproduce the work of authorship in copies, where copies is a defined term, and it requires that the copy is capable of being perceived, reproduced, or otherwise communicated for a period of more than transitory duration. And so this is where in the digital environment, you got to watch out for the copyright hooks. So we got a Court of Appeals opinion on this for the following reason. Cablevision decided that it would set up a remote DVR. You don't have to go buy your own box. You don't have, we'll host the box on our property, but it's your box. You control it. You get to record whatever TV shows you want. You get to play, erase. We'll just record it for you. So there's prior law that says that when users do that for themselves, that's a fair use. That's not copyright infringement. But the copyright owners were very upset by this because this was almost creating a kind of video on demand market that they want to own. So they needed a copyright hook to try to go after Cablevision, and the only hook they had was this 1.2 seconds of a buffer copy before the show went onto the user's drive. And they sued them for that 1.2 seconds, saying, you're copyright infringing, you're making copies of my television show. And the Second Circuit Court of Appeals said, no, that's not a copy that counts. The transitory duration, that's a transitory duration. So just as that little buffer copy in that case is not a copy and therefore doesn't fall within copyright, same thing for these temporary copies that get made in the course of text mining. Now, researchers also want to make reference copies. They want to hold on to a durable copy of the article, but just as a reference to validate the text mining. If that's the only reason you're holding on to that copy and making it, in my view and in the view of other legal scholars, that's a fair use because you're not out there in the market distributing these to everyone. It's a dark copy just for your own purposes. So the text mining is not a copy in itself. The reference copy is a fair use copy. So that's a user's right to do those two things. And if you sign away the rights to do that, which you might have to in order to get that initial access, but let's just be clear about what the negotiation is. It's not getting a license from the publisher. It's giving up a user's right in exchange for that initial access. I'm sorry that's a little bit down in the weeds, but that's a really important. The publishers are trying to create a separate market in text mining. And so this is this moment. It's a choice point in where the environment's going to evolve. And open access, one of its best features is the ability to enable text mining so that we can learn more from each other more efficiently using these machines. And so we need to make sure we get this piece of the environment right. All right, back to basics. To transfer a copyright, he says, one has to sign a document. There's a formality. So when the publisher sends that form to the author, if you don't sign that and they publish it, you still have your copyright. They have permission from you to publish it, but you still own the copyright. They only get ownership if you sign a document. And that's why they've become more aggressive about making sure you do that signing. In the alternative, non-exclusive licenses can be granted quite casually. Hey, can I have permission to use your song in my video? Sure, that's a copyright license. It's a non-exclusive copyright license, but that's a copyright license. But once the copyright is transferred, the author retains no rights. That means they cannot make copies of their own work because they gave away the rights to do that. And so signing that document has real legal consequences. And let's take a minute to look at what happens when one by one authors sign that document and you aggregate all of those copyrights that flow out of the university into the publishers. You get this, and Heather had her version, here's mine, right? It's, I want an article from Cell Press, and you can't read this, but up at the top it says, to view the full text, please log in as a subscriber or purchase a subscription. So let me just translate what this is saying, right? That's what it's saying, right? Okay, here's the thing. Authors have to take responsibility for their actions. It is by signing those agreements one by one that you get an environment where access is denied. Authors may not like it, but they are slamming the door in the face of potential readers when they sign away their copyrights and don't provide open access. Right? This is the ethical moment. This is the choice point. It is time to change that behavior. That just like in the recycling, when we used to just throw our cans, in the trash, and we threw our newspaper in the trash, and it all went into the landfill, right? These copyrights are getting, it's almost like landfill. Those copyrights are bundling up inside these publishers who are now using the leverage to extract large sort of wealth transfers out of the university and into the shareholders' pockets of the publishers of at least 50% of the literature. And that has to change. And the only way it can change is if authors stop signing the agreement that they're given and change the terms of that agreement so that they ensure that they have the rights to provide open access to create the open environment. Now, why do that? Right? Well, here's why. As Heather said, when we use the word open, you've got to think open in terms of access and terms of use. We're evolving away from just caring about access to use, but we're still at the phase where we don't have access. And so access remains a critical problem, but we cannot ignore the reuse issues. In my view, here are the audiences that you shut out when you don't provide open access. First is the group I call serendipitous readers. These are researchers who have paid access, but they happen to be at home using Google. And they read a blog entry in their field, and then they see a link to a paper, and they follow the link, and they say, wow, that's cool. And they probably wouldn't sign in through the library portal to go find the sort of licensed copy. So it's a serendipitous discovery made because there's an easy link on the open web where that extra little bit of friction just would have been enough to stop that information connection from happening. In addition, we have all the under-resourced readers out there. Heather gave you some of the pricing data. $30 an article, in a lot of cases, $10 an article for a JSTOR article. It's expensive, and there's a lot of people who are priced out of the market. And why do that? We've got this internet thingy, don't we? There's no good reason to price all those people out. In addition, where you have institutions that have disciplinary collections, does that really mean that the literature being published outside of all those disciplines is entirely irrelevant? Not necessarily. Increasingly, we're seeing insights cross disciplinary boundaries, but we're not seeing that researchers have easy access to those other literatures. Again, in an open access environment, empowered by good text mining software that can help you find correlations in other bodies of literature, we can be smarter, faster, better, right? And this is true at the global level, but it only works if you have access to the machine readers. And here I want to emphasize, you cannot get the benefits of text mining unless you have an open access environment. The publishers want to tell you that through Crossref, and versions like Crossref, in which we will allow federated searches of our proprietary databases, you will get the benefits. It doesn't work. The machine has to negotiate all these different protocols, log into all these different databases, And you will not get the full effects of what the technology can do for us in terms of learning what we know unless you have an open access environment. And to me, this is one of the most important upsides for open access, one of the most important reasons why we need to fight for open access. All right. And it's good for authors. They get cited more. They get more attention if they're out in the open. The data shows this. So asking them not to sign that agreement so that they can provide open access, we are not asking them to eat their spinach, right? This is candy. And so if citations are what you want, citations are what you're going to get. Go open access. And it's happening, right? The gold open access publishing model is changing. We see increasingly the commercial publishers see this business model where the supply side is funding it and the reader side gets free access immediately. It is only about 3% of the literature right now, so let's not overstate the case. But this publishing model is the fastest growing trend in scholarly communication at a really sharp clip. And it is important to emphasize that this model of author pays or authors don't always pay. Just because readers get free access doesn't mean the costs are always borne by a per article charge. Some journals, like this journal, Philosopher's Imprint, is published at the University of Michigan, published by librarians using the fumes of overhead to support the server costs and a little bit of staff time. And it's the editorial board is the philosophy department at the University of Michigan. So there are many other examples in many other disciplines where it is the free lunch in a sense, because the marginal cost of producing these kind of publications is so small that it doesn't make sense to try to do this on a per article basis. There are other funds in the institution that can handle this, and if other universities step up, so Michigan sort of put its cards on the table. Can Oklahoma University step up? Can OSU step up and do this in another discipline so that everybody contributes into this environment? The other thing is, when we talk about these journals where the author, the supply side funds whatever costs are necessary, and none of the readers are not paying anything. The readers are being given a CC BY license. You all know CC BY, right? Yeah. Well, maybe you do, in which case that would be great. The talk's over. But I'm going to assume that not everyone knows what that is. That's code for a Creative Commons license. Creative Commons creates 6 versions of permissions that you can give to the public. And you can just say, okay, here's the deal. I'm the copyright owner. Here are the set of permissions that I'm willing to give you. CC BY is the most open of those. It says the only condition I have is that you give me credit when you reuse my work. Otherwise, go to town, translate it into another language, turn it into a video, do whatever you want as long as I get credit. And you can't use that credit to imply that I'm endorsing what you've done with my work. You simply have to identify me as the source of the source work, but you can't sort of say that I approve of your translation or I approve of what you've done. So these are the different conditions that you get to choose from in a Creative Commons, and when you mix and match these up, they produce 6 possible options. So CC BY is the attribution is the only condition. The essay, the share alike, is what we sometimes call a reach-through license. It's I have a copyright, you're going to use my copyrighted work to produce another copyrighted work. I'm going to reach through and ask you to license your copyrighted work under the same license that mine was. And this is what Wikipedia uses. So if you copy text from Wikipedia and use it in your article, use it in a textbook, and create a derivative work, and there's a subtlety here. If all you do is copy-paste, you are not creating a derivative work, and so you're not under this share-alike obligation. But if you take the text and you mash it up, you amplify it, you do things to the text, then you are creating a derivative work, and you have to license that work under the same license. Non-commercial means that somebody wants to hold back the commercial rights, and you have to go back to the copyright owner if you want a commercial license. And then ND says, copy paste is all I'm letting you do. I don't want you to make that derivative work. I don't want you to translate it without talking to me. And so one thing to be clear, the CC license is just saying, these are the terms I'm willing to give everybody right away. And if you want additional permissions, come and ask me. So it doesn't mean the author's saying I won't give you any other permissions. It just means we got to do it old school one-on-one. In addition, if you say, we don't need a copyright here, we have two ways to respond to that. If the CC0 is a waiver of copyright. It says, I don't need copyright, I'm giving it away. The public domain mark says there is no copyright here and I'm simply labeling this as being in the public domain. And when you get it, then that's sort of the spectrum. And I'm running out of time, so I'm going to blow through this because we got to, how much time? I'm over? 5 minutes? Okay, okay. So let me just say, there's one other thing that's happening in the scholarly landscape that may affect the pace of open access publishing, which is publishers tell us that the most important service that they provide is peer review. Okay, they don't really provide peer review. They provide the cost of coordinating peer review. The referees do the work for free, but the referees need someone to send them the article and chase after them and remind them to please get their reviews in and then to adjudicate if there's a dispute. That's the editor's job. And everyone tells us that we need peer review, but let's examine peer review for a minute. What we're talking about is pre-publication peer review. And pre-publication peer review is important in an analog environment where you had scarce paper resources that cost a lot of money to print and distribute. And you wanted to make sure that the ink you were putting on paper was reporting information that was of sufficient quality to make that investment worthwhile. And so the pre-vetting was part of a quality control associated with cost control. And peer review traditionally has answered two different questions. Is this valid research? And if it is, how good is it? How important is it? And that second question, how important is it, tells you which brand name you get on your CV. Right? If this is a breathtaking result, then I get to be in the lead journal in my field. If it's not so good, or if people think I haven't done my research as well as I could have, I go down the pecking order. But again, why should we necessarily answer that second question anymore? Why not just validate that this is valid research according to the professional norms of our discipline, and then let's let the market decide how important the article is. And a recent, I don't know if you saw in the New York Times, but a recent example of why it's disadvantageous to have that second question asked, and again, this is a science example, but these researchers did 10 years of studies on human beings to study sepsis. It's a disease. And they had all of this DNA data showing us about the nature of this disease in human beings. This is groundbreaking research. Science rejects it, nature rejects it. It finally gets published in the Proceedings of the National Academies of Sciences only because one of the authors has an in there. And the reason it gets rejected, they find out, is the referee saying, yeah, that's fine, you've studied the DNA in humans, but you didn't validate it by showing that this is how it works in mice. And in our discipline, you need data from mice to show that this is important. And the researcher said, are you kidding me? We spent 10 years gathering data from human beings to show how it works in humans, and we have to... And then they went and tested the mice, and they learned it doesn't work in mice because mice are not good models for this disease, and we've spent billions of dollars chasing after cures for this disease because we're trying to cure it in mice. And it doesn't work when you get to humans. All of these drugs have failed when they get to humans because the biology is different. And the paper gets rejected because they found out the biology was different, and the reviewers all said, no, mice are the way, the biology is the same. So asking that second peer review question can be disadvantageous, and maybe we should trust the internet a little more to help us sort through the wheat and the chaff, and let's just validate the research and then move on. And that matters because PLOS One is a journal that that takes that view. We're only going to validate the research, and then you guys decide how important it is. It's publishing 4,000 plus articles a year. It's the fastest growing science journal. And so there's a suggestion that other disciplines may agree with this idea. And that means there's going to be a shift in the market power, if you will, because all of those brands that the publishers have built their market power around that second question: how important is this? And if we shift our idea about what peer review is, it's going to change the landscape for publishers in a big way. All right, what can you do now? You can do those things. All right, the last, I'm really done now. These are just the mechanics. If OU were to adopt a policy, here's how it would work. You make a forward-looking commitment that says, I am a potential author of works of scholarship, and I hereby give you a copyright license to those works that don't yet exist. Can you do that? Yes, you can. It's a commitment that you make right now. What happens then is you make that commitment, and then when the article is written, the copyright showers down, and the license immediately is granted to the university. So Rick gets his license the minute that final draft is done. Before the publisher gets to the author, the license has already gone to the university or has gone to the funding agency. And at that point then, when it comes time to sign that agreement, the author has to read it. Sorry, they have to read it, because if it says you hereby give away all your copyrights, you can't, because you already gave the license, a non-exclusive license to the university, and that non-exclusive license has to be recognized in the terms and conditions of the copyright transfer. And that can be done easily. We've got standardized forms. I wrote one. Other people have written them. Happy to point authors to this, where all you do is sign this form, staple it to the publisher's agreement, write under your signature on the publisher's agreement, I'm signing this subject to the attached addendum, and then you send it to the publisher, and you're basically saying, if you want my copyright, it's on my terms, not yours. My terms require me to say that I've given a license to my university, I've given a license to my funder, and then the publisher has to deal with that. And here's the thing, in the early days, everyone said, oh, they won't do it, they won't do it. They have. Publishers have all changed their copyright agreements to acknowledge the NIH policy. Now they're going to change those publishing agreements to acknowledge the new government policies that are coming down. They've changed it to recognize the university policies, or the universities that have negotiated. So this is doable, but it's got to be done right to really make it a stable solution. And with that, I think I burned up all my time, but I had so much I wanted to share with you. Thank you. The dean has given permission for 2 questions. And I'm around at the break and everything, happy to, but questions of general interest?
The addendum idea, does it mean that the author no longer has to make a decision between the value of their trademark and the value of open access?
Right. I think unless the publisher says, no, I'm sorry, I will only publish your article under my terms and not under any varied terms. But what you're saying is, I want to publish with you, but I need to acknowledge that I've already given a license because the funding agency said I had to, or I have a university policy that said I had to. And the publisher then has a choice whether to accept those terms or not. And some of these university policies allow for an opt-out. So the Harvard policy, for example, says Harvard gets that license, but if the publisher refuses to publish unless it's my way or the highway, then the author is allowed to waive the Harvard license so that they can go ahead and publish. So nothing about these policies are in any way designed to limit authors' choices about where they publish, but the publishers are more flexible than authors assume. Authors also make the mistake of thinking that a publisher's suddenly going to decide not to publish if they receive one of these addenda. This is like, they're business people. It's a negotiation. If they don't want to publish under those terms, they'll tell you. They still want to publish your article. They'll just say, these are the terms that we want to publish under. You had the...
So my question is, I look up a journal in Sherpa Romeo, and it says that I can post a preprint or a post-print. Does that apply to an article I wrote in 1984?
You know, that's a great question. So this is not legal advice, but here is my view: is because a copyright owner can give permission quite casually, and because most of those publishers, let me put it this way: if it were published in a journal from one of the publishers that has an author policy, so there's sort of two layers. There's the actual publication agreement, and those are the terms of the agreement. But then they also have these general policies up on their website where they try to inform authors about what rights they're willing to acknowledge. If they have an author policy that says you can put, a copy of your final version in the institutional repository, I would argue that that's a non-exclusive license, that they are granting you a license to do that, and that would apply retroactively. And honestly, a 1984 article, the likelihood that anyone's going to complain is... That's what I would do if it were my work. I think that's it. All right, but I'm definitely around because there's usually like fair use questions hiding under the table and things like that, and I'm happy to grok on those as well. But thank you guys very much.